If she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right. You heard Mr. Steele. Mr. Steele said, Your Honor, I am willing to surrender my bar card and have her surrender her bar card if what she is saying is true. He wasn't wrong.
Today we're going to look back at a video from April 24th of this year, day 67 of the YSL trial, and we're going to see Miss Love toy with her duty of candor to the court. This is going to involve a video with Jeffery Williams, aka Young Thug, and some persons in the background who, according to Love, aren't saying anything, but then they really are. So let's see how this plays out.
Investigator Gaither, at the time that you were in January of 2015, did you, along with your partner, did you all begin to look through social media pages that were open to the public of persons you believe were involved with YSL?
Yes. I stand the objection.
Did you have an opportunity to look through Demekion Garlington's social media pages?
I have several times.
Okay. And in looking through those social media pages, did you come across a video of Jeffery Williams talking into the camera?
Yes.
Okay. Your Honor, with the court's permission, I'm going to approach, but not before showing to counsel for the defendant what I have labeled as State's Exhibit 112, Bravo, Bravo.
They're already like, hold up, what's gonna happen here? Look at Keith Adams' face.
Madam, before you do that, can I get you and a member of the defense team to come up, please?
Yes, Judge.
Judge
Yeah,
already
fine.
peeps it.
We'll go ahead and recess for lunch. So if you could please be back in your headquarters so we can begin at 1:15.
And then there's also a part from day 67 that's unrelated to what this video is about, but it's another thing we heard about recently with missing photos. And again, missing reports possibly. And how Love handles her responsibility to inquire and produce things that the state should disclose if they have them. So let's hear what Shart says here. Again, this is unrelated to the point of this video, but it's relevant to the things we've been talking about and hearing about recently.
And this is why I'm asking now, because Investigator Gaither's on the stand regarding a January 10th meeting between Investigator Gaither and Kenneth Copeland. We brought that up a couple of days ago, and we haven't heard back from the state. So I am checking on that. And also, Your Honor, the second thing is there were yesterday on direct, Investigator Gaither, in response to Ms. Love's questions, indicated that she had spoke to Terrion Moody on this case, indicated that she had spoke to Cornelius Davis about this case, and had indicated that she spoke to Christian James on this case. Those are three of the individuals that are in the car with Dexter Montgomery. In the discovery provided, at least to my knowledge, there's no police reports documenting this or taped conversations documenting this. Now, I'm not denying that there's a possibility that they weren't documented, but I just want to make sure that there's no documentation that is missing.
Okay. Ms. Love, addressing that point number one, is there any police report in regards to that conversation?
Your Honor.
Did you check and make sure that there was not any?
I did not.
There was receptive to that, or
I am receptive
responsive
to
to
it.
that particular issue?
I didn't get asked that question until now. I can ask.
So right there, it's, well, I never checked because nobody asked me first.
We did not have one. I know that, as you can see in the video file, when Investigator Gaither is talking to Walter Murphy, there are images that we don't have and didn't have and couldn't find. The images of the still shots from the surveillance footage, but I did not ask the question that Mr. Shart just asked. I can inquire now. That's the first time that he's brought it to my attention.
So we know that we don't have these still images. We already know that. And we just heard the same thing referenced recently. But while we were inquiring, or we found out that we don't have these still images, we didn't ask about any recordings of these interviews or notes or reports from them. But we made sure we didn't have those pictures. Why wouldn't you ask about other things? Well, if you don't have the pictures, do you have reports documenting, during that you showed the pictures of this and this is what those pictures showed? If you're missing something crucial, wouldn't you try to get a plan B? Wouldn't you ask about these reports? And here she's saying she never asked because Shard never asked her a question until right now.
I asked about that a couple of days ago.
He did.
About the
January 10th conversation.
That was different. Now, when he asked me about the January 10th conversation with Kenneth Copeland, I did ask her that.
Does it exist?
She said that to the best of her recollection, she talked to him that night, but she doesn't know whether or not she's on camera. She said she seems to remember talking to him.
Was it
that night.
memorialized in any fashion? Other than what we see on tape?
Yes, so I didn't ask that. I'll
Okay,
ask
you
her
can
that.
ask her that, and can you ask her if there are any reports from the other three individuals?
Yes, I will ask her
Did you
that.
ask her that already, or what?
No, I didn't ask about the other three individuals. This is the first. I'll go ask about the other one now. So
All right.
1 second, she's outside.
Okay.
And then she's outside for like 8 minutes and then comes back in.
Yes.
And then we have a pretty long sidebar, and you can see Miss Love is talking most of the time. She's holding a microphone. We can't hear it. And then we see Judge. It looks like Judge is looking at Love when he's saying something pretty tensely. And this goes on and on, you guys. This is a long sidebar. That was like a 20-minute sidebar. And then Miss Love gets into some questioning with Detective Gaither when Detective Gaither gets back on the stand. But I'm going to fast forward a few questions to when we are talking about Exhibit 112 Bravo Bravo.
Gang and YSL. Did you and your partner have an opportunity to look at the social media page for Demikion Garland?
Yes.
Madam, can you speak up to?
Yes.
And around January 26th of 2015, did you locate a video posted around January 26th of 2015 depicting Mr. Williams displayed on Mr. Garlington's social media page?
Yes.
Showing you what has been marked as State's Exhibit 112 Bravo Bravo. Also on the thumb drive that you identified earlier.
Measure.
Before I tender it, I'll bring it over. Have you had an opportunity to look at, and is this the video that you all located on Mr. Garlington's social media page?
Yes.
And was this from January 26, 2015?
Yes.
And is this an accurate reflection of the page as you all captured it?
Yes.
Does the video depicted in State's Exhibit 112 Bravo Bravo have sound to it?
It does.
And does it have more than one voice?
Yes.
Do you recognize the voices?
Mr. Williams and I want to speculate on the second person, but I do.
Your Honor, State Tender State's Exhibit 112 Bravo Bravo as evidence.
Any objection states 112 Bravo Bravo.
Yes, sir.
Basis.
Foundation is to repost.
Your Honor, the witness has laid
Speak in front of the jury.
Y'all come on up.
this.
Come on.
So they're going to do it in a sidebar, but essentially it's a repost. So how do you know when it was actually recorded? What's the foundation for when that video was actually first made? You can hear, you could see Steele making an argument. Love's responding. I feel like Love a little bit is like holding them hostage up here until she gets an answer that she likes. Like, she's just... Miss Trish, YSL Granny. Deep sigh into the microphone.
Sergeant Gaither, I'm going to ask you a few more questions about State's Exhibit 112 Bravo Bravo. Did you recognize the person who was depicted in the video visually?
Yes.
She's got to lay this
And did you
foundation
recognize
better.
the voice of the person depicted in the video?
Yes.
Was the video obtained from a public social media site that was accessible to anyone who is looking at that site?
Yes.
We will come back to that. Sergeant Gaither, as we are getting a last exhibit, and Your Honor, we are intending to bring back the one that we tendered a moment ago with the court's
112.
instruction.
Which
With the
is,
court's instruction, not
Which one
permission,
now?
but instruction.
The 112
Brady
Bravo
Brady.
Bravo
Bravo.
that takes out the portion of the second speaker.
are you trying to tender it at this point in time, madam?
Your Honor, we would tender that exhibit with the caveat
Where the
that,
court's earlier ruling?
yes, Your Honor, yes.
Any further objection, counsels, to states 112 Bravo Bravo
Yes.
basis? Okay, Ms. Love, show that to
It's being,
counsel, please.
it's being redacted. And so before we display it or anything, we will show it to all the councils because that portion,
Oh, bless you.
is being redacted. Thank you. And Your Honor, with the exception of the video that we are redacting with the court's ruling, I don't have any further questions at this time. With the court's permission to play that video after it's properly redacted and defense has had an opportunity to look at it.
Counsels, can I see you for a second, please? Just, you don't,
Okay, so they give the jury a comfort break.
two parts to it. One is just a picture of it. So let me see, first let me see states.
So picture of
112
the
Bravo
post,
Bravo to begin
screenshot
with.
of the post.
This is apparently the Instagram post, January 26th of 2016,
2015, Your Honor.
2015.
Yes, Your Honor.
All right, let me see it.
And then we come back 10 minutes later with some words cut off.
Himself as a figurehead, he's saying that's for me and my gang, me and YSL. Y'all need to be killed. Those words are wholly inconsistent with this notion that we just produce rap music for the good of everybody. And so, Judge, given that the speaker of the snitch and bitchin' comment is doing nothing but co-signing the main message that Mr. Williams is speaking, and given that the video itself was publicly posted, we would ask, in light of the cases that we have cited, along with United States versus Bagley, Bagguley, at 1987 US APP Lexus 18712, Fourth Circuit in United States versus Bagley, the court said that the contentions of the appellant raised seemingly disparate concerns, but at least the first four of them converge insofar as they allege the authenticity and reliability of the tapes. The first contention, that identification of all speakers is necessary before tapes are admitted, refers to one of 7 requirements often enunciated by courts for the admission of tape recordings. But the primary aim of these requirements is to give the assurance that the tapes are accurate. The goal of accuracy is sufficiently satisfied even when all the speakers are not identified, as long as relevant speakers are. In the challenge recordings in Bagley, the court found that the more relevant party was the caller, who in each case was an identified member of the conspiracy. And insofar as the conversations may be deciphered to involve the heroin scheme, the names of the recipients of the calls were not critical to the tape's accuracy or their relevance. Therefore, the trial court properly admitted them despite the failure to identify every party. And this is a Fourth Circuit case applying a test from the Fifth Circuit.
And what Love is trying to do here is get this video in so she can show the jury what she says Jeffery Williams is saying, and that it only matters what Jeffery Williams is saying, even though we can't identify the people in the background, which means that the defense can't really confront those people in the background, that there should be an exception to the state having to identify these individuals and possibly what or if they're saying anything to be able to get this video in for the statements by Jeffery Williams. And let's hear what goes on. Let's hear the responses here.
Bagley is.
Prior to the new evidence code?
Bagley is prior, but Hampton is in 2022, and Hernandez Garcia's is 2013. Of course, the new evidence code came out in 2013. And we also have others from after the new evidence code as well. 2014, United States versus Reeves. That site is 742 F 3rd 487, 501 through 5.
11th Circuit.
This is the 11th Circuit. United States versus Reeves is the 11th Circuit, Your Honor.
And what is that?
The site is 742 F 3rd 487 at Penn Site 501 through 502. And in Reeves, the court cited Biggins, Bigdins, which was a Fifth Circuit case. And Reeves, the court said that the government carries the burden of proving four things, the most relevant of which is the identification of the relevant speakers. But even if one or more of the requirements has not been satisfied, if there is independent evidence of the accuracy of the tape recording admitted, we shall be extremely reluctant to disturb the trial court's decision to admit the recording. They point out that under the federal rules of evidence, an opinion identifying a person's voice based on hearing that voice at any time under circumstances that connected with the alleged speaker can satisfy Rule 901. And they cited Fifth Circuit 1979 case for that proposition. So for our purposes, as we've alleged and stated from the beginning, the person that we identified in the overt act listed in the indictment was Mr. Williams. His words were the overt act that we alleged in the indictment in Act 26. Mr. Williams is the relevant speaker. His words are the relevant words, and the persons who are behind him talking are simply co-signing.
Okay, you said that twice now. Okay.
I won't say it again.
All right, so let me hear from your colleagues across the table here. Mr. Steele,
Yes, sir.
you want to start out, please?
Garcia.
Apologies. In both Hernandez-Garcia versus State 322 Georgia Appeal 455, 2013 case, it's a Division 4A. What our court said is here the witness called by the state to authenticate the recordings and transcripts testified that she had heard the conversations as they occurred and were recorded, and she had transcribed the conversation as she heard them and they were being recorded, and that the transcripts accurately reflected the recorded conversations.
Sounds quite a bit different than somebody seeing a social media post and then listening to it.
United States versus Reeves, Reeves, 742 F 3rd 487, 11th Circuit. Our 11th Circuit said under Division A, in order to introduce a recording at trial, the government must establish that it is an accurate reproduction of relevant sounds previously audited by a witness. Plainly, the government carries the burden of proving the competency of the operator, the fidelity of the recording equipment, the absence of material deletions, additions, or alterations in the relevant portions of the recording, and that the identification of the relevant speakers. But even if one or more of these requirements has not been satisfied, if there is independent evidence of the accuracy of the tape recording, admitted trial.
So they don't have any testimony from a witness present within this recording. They only have Gaither saying, oh, I looked at that post, which is not the same thing as someone having firsthand knowledge of when it was recorded, who was there, and what was actually said during that time frame. So when you hear mentions of Rule 901, and mind you, Steele is looking at the same cases that Love just used to make her argument, but Steele is bringing in this extremely relevant context to the appellate court's decisions that Love didn't include in her argument or even try to address. She just said, well, the trial court decided to bring it in and the appellate court didn't want to disturb that. But here Steele's like, well, the appeals court, these cases, they let it in for a reason, possibly, because they actually had a witness with firsthand knowledge. And so in my opinion, Love was vaguely trying to say that, oh, Detective Gaither, her saying that she saw the video go up on social media, was enough to meet the criteria for Rule 901, which means we want to be able to authenticate and identify an item of evidence. There needs to be evidence sufficient to support a finding that the item is what the proponent claims it is. Such as through testimony of a witness with knowledge, that the item is what it is claimed to be. Now, can Gaither give that knowledge? She could say it was a social media post, but can she say it was a video that was recorded on the day the social media post was posted? That what's contained within that video is unaltered? That what's contained within that video is complete? And further, opinions about a voice, an opinion identifying a person's voice, whether heard firsthand or through mechanical or electronic transmission or recording, based on hearing the voice at any time under circumstances that connect it with the alleged speaker. But we heard Detective Gaither. She was about to be asked, Love was about to ask her, do you know the other speaker? Don't speculate. And we don't get anything here from Detective Gaither trying to identify this other voice in the background. So we're missing these parts.
We shall be extremely reluctant to disturb the trial court's decision to admit the recording. These are all foundational. That's why you, I didn't mean to turn my back. I came back to the computer. That's why you told me over my objection, I could not get in the lifestyle recording. It's a song by Rich Gang. When I had Trantata Stevens on the phone or on the stand, you said to me, he doesn't know. You said you could get it in with someone else. It's Mr. Williams' words. You're showing that it's not a member of a gang that has a real lawful purpose, but you have the wrong witness.
Okay, why wouldn't, I'm just asking this question, Mr. Steele. Why wouldn't just when it boils down to it, the statements reportedly made by your client, why wouldn't those be admissions of a party opponent?
They need to be identified as when they were made. It's a repost. What you're being shown is a repost. Are they the same statements? People change things all the time. Like the state was going to redact here. In the background, we started out with the state saying, you only hear yeah by other identified persons. You clearly hear the person saying, I'm going to lie on God. Snitching, I'm not going to say it, but B-I-T blank H-E-S. F, and then the N blank G-G-A. That's as far as I can blank you. So help you God. It's 17 seconds, and there are multiple speakers. It's not just two speakers, it's multiple speakers that right now, the state may be able to get it in. It's just like you told me. I'm not saying this may not be evidence that's important to the case. What I'm saying is there has to be the same foundation that the state lays that you're making me lay, and that's what the case law supports. Now, if you let it in, an appellate court, they may say it was error, harmless error, it wasn't an abuse of discretion, it wasn't abuse of discretion. We understand that, but we're here now. The state cannot lay the foundation. They need a different witness. They don't have the time, just like in the last series of jail calls. You had to say what the date was. The witness was able to provide the dates. They have the dates here. They know a reposting. They don't know if it's the accurate statements. They are taking something off of the internet. It is exactly what you have told me. In the other cases that the state has cited, the witness was a member of those conversations, heard them live and said, those are the conversations. I don't know the other people, but that is exactly what was said. That goes to weight.
And Gaither was
Here,
not
they
a
don't know
live
what was
witness.
said. They know it's a repost. That is my statement.
All right, sir. Thank you.
Thank you.
Anybody else? All right, let me take a few minutes out, and I need to take comfort, and I'll think about it, and we'll come back.
Your Honor, can I get the report?
No more seconds, okay? I'm taking my break. Everybody should.
Let's listen to that again.
Take a few minutes out, and I need to take comfort, and I'll think about it, and we'll come back.
Your Honor, can I get the report?
No more seconds, okay? I'm taking my break. Everybody should. We're in recess.
Yeah. Oh boy. So they take their recess. Okay, so they come back.
Okay, the court's had an opportunity to kind of consider the issue presented to it as to the exhibit. That being states 112 Bravo was the digital media of the incident involving the posting of January 26th of 2015. I'm going to sustain the objection as the foundation at this time. However, much like many of the rulings I've made, they're subject to reconsideration. In this particular circumstance, I believe that it is the opinion of the court that the original video as presented would at least the source would have to be at least identified for the purposes to make sure that there were no alterations of that particular video. I don't know whether or not they are, but I think that'd be part of the foundation in this case. So for example, when we haven't had testimony of this quite yet, if it can be shown that this particular video came from Mr. Williams' Instagram page or some other social media site, and it's public and posted, and then it was regrabbed and reposted, then that would finish the foundation in the court's opinion. And the other issues that the court would take up at that point in time as to what it would play and for what purpose. Okay, so I'm going to sustain the objection right now, but if you can lay more foundation another time, I'll reconsider it. Okay.
Yes, Your Honor. And to understand, Your Honor, is the court saying that only postings of a party opponent on the party opponent's website can be?
No. It has you have multiple issues with this particular piece of evidence. We haven't gotten to the reason that you want to put it in. That's separate, okay? The first part has to be the foundational aspect of, is it true and is it authentic? So in order for you to do that, you need to show where the original posting came from, so there's no alteration of that particular post. I would need to see that in order for me to kind of make a further decisions on whether or not that particular statement is admissible. I mean, so I'll get to that.
And hold on, this is a stupid reason to pause, but notice his shirt is like this bluish and white square pattern button-down shirt. Remember that day we were trying to debate if this was Glanville or just an IT guy that looked like Glanville? I think that's the same shirt. So we were a little confused. I think we were split in the chat 50-50. But that seems to be the same shirt. Anyway, back to our regularly scheduled program here.
But I think that if you can show that where it came from to begin with, that there's some reliability that, hey, it came from Mr. Williams' website or a post from Mr. Williams, then I'll reconsider it at that point in time. I just haven't heard any testimony about that.
I didn't know if the court saw at the bottom, it said at Thugger 1, it referred to Mr. Williams' website.
I understand that,
And so.
but it's still a reposting.
And in doing so, Mr. Garlington was adoptively admitting Mr. Williams' words, as our evidence book says, statements of a party opponent are admissible without presentation of any predicate or foundation. The definitional exemption for individuals.
Where's that?
It's on page 463. It's in 24-801 D2A. It's
24-8 what?
801.
24-8 that's what?
801, Your Honor. Delta 2 Alpha. And it is under the heading Foundational Factors. And for the court's edification, it's the 8th edition, page 463, the 3rd paragraph down.
What paragraph? I'm sorry.
It is paragraph 3 that starts with statements of a party opponent are admissible without presentation of any predicate or foundation. The definitional exemption for individual admissions is extraordinarily broad, with exemption for individual admissions having almost infinite breadth. In addition, an admission of a party opponent needs no indicia of trustworthiness to be admitted. The party admission must be relevant, and the party admissions are not subject to the personal knowledge requirements of Federal Rules of Evidence 602. In addition, courts recognize the freedom that admissions enjoy from, quote, the restrictive influences of the opinion rule. They go on to point to the fact that the District of Columbia Court of Appeals explained the generous treatment that the introduction of party admission receives. Party admissions differ from most out-of-court statements in that their admissibility does not require the demonstration of guarantees of trustworthiness, but is based rather upon the identity of the speaker. Therefore, party admissions do not require foundations to be admissible as substantive evidence. They need not have been made on personal knowledge and may be in opinion form, so long as the statement is fairly attributable to the party. It makes no difference whether the adopting party had any personal knowledge of the truth of the matters mentioned in the statement. And then it goes on to show.
That's plenty. All right, Ms. Steele, I'll give you the last word because it looks like I may have read too early. So.
I believe you read too early. Statement of a party admission has to be an admission.
Party opponent.
An admission by a party opponent, I thought.
Admission by a party opponent. Yes, sir.
An admission has a specific text and connotation in law. It's different than a confession, which admits all elements. An admission admits some of the elements. Here, this is a statement. The state still has to be bound by the foundational requirements that you have sustained the objection through.
Okay, stop. Please,
Yes, sir.
please don't go back to that. I have to make them on an individual basis. All right. So why wouldn't this be an admission of a party opponent, your client, if a jury chose to believe it?
Because 3 reasons, and you've already said it. You don't have a date.
But it looks like from looking at Carlson and 24-8-801 D2 alpha, that's what it indicates here, that statements of a party opponent are admissible without presentation of any predicate or foundation.
Because it's not an admission, so you still need the foundation.
Why wouldn't it be an admission? If it's believed by the jury for what it stated in the statement, it goes to whether or not your client's a leader. It goes to whether or not he has control. It goes to several other purposes that the state mentioned.
Because without foundation being laid for that date, you don't know, you can't say what it's an admission to.
Earlier, in terms of his relationship to YSL, intent. So if the jury believes that, because that's certainly within their purview. But why wouldn't it be a party admission by a party opponent for that reason?
Because the state is saying, they charge it an overt act, that this statement was made, reposted on the 26th day of January 2015. There's no evidence of that.
But it looks like, I'm sorry, go ahead, sir, I apologize, go ahead. I'm sorry, go ahead.
My position is it's not an admission without there's some sort of context. This was said for this reason, to stop people from cooperating, or this was said for this reason.
But that's what the jury needs to decide on that issue.
Foundational requirement, like you said,
I
believe a foundation still is the.
okay. While I did say that, Mr. Steele, it looks like that, of course, I have to look at things in the light of what you all tell me, and also the statutes and the law applicable. But it appears that it looks like from statements of a party opponent are admissible without presentation. If I believe that the statements in 112 Bravo, the digital media from January 26, 2015 are in fact an admission against interest.
I don't believe.
Or admission of a party opponent, I should say.
I don't believe that it fits in that category because we don't have any of the date that it was made. If it was truly that statement of Mr. Williams, I still say that the state, they started out with, it's all Mr. Williams' statement and there's nothing else said except, yeah, I'm indiscernible. That's wrong. Then they started out with, they don't have to identify the speaker. I believe that's wrong. And now they are at a position
So some insight into those long sidebars.
where they don't have to lay any foundation because it has to be an admission of a party.
But it looks like under 24-8-801 D2A that it's not required.
Okay.
It's not required.
Well, then
And I'm looking at the statute right now, and it says admission shall not be excluded by the hearsay rule. An admission is a statement offered against the party. A statement means an oral or written assertion or a nonverbal contact of a person is if it's intended by the person as an assertion. Your client is allegedly making a statement in this particular video, which arguably is an admission by a party opponent for what the state is claiming in Act 26, as well as count 1. So, I mean, and that's where the jury decide, but whether or not they want to take it as that. But it appears that if I'm reading 801 D2A correctly, that the foundation's been met.
Well, then I didn't know about this when you broke. If I would have known about this issue, I would have done it over the break. I just learned about it. I'm assuming the court learned about the state's new position. I'd like time to look at it because my memory is this is not an admission, but I have to get you the cases. I can't cite a case to you off the top of my head. I apologize. I can't do it.
No, I mean, look, I'll give you 5 or 10 minutes if you can find me a case that says it's not a statement against interest or a statement by a party opponent, but admission by a party opponent.
And so this is the trick because count 26 is participation in criminal street gang activity. It's that vague, broad, all-encompassing thing. So that's giving some gray area here for Judge Glanville to say, well, we'll leave it up to the jury to decide.
I'll take that into consideration, sir. Okay.
Thank you.
All right. So I'm just gonna pause for just about 10 minutes, and I'll go ahead and let you.
So another break.
Oh, there he is. Okay. All right. Let me go ahead and just as an opening kind of to the court's addendum, just tell you that I'm only going to consider the statement and want to hear argument as to whether or not it falls within 24-8-801 D2A, because from doing a little more research, if it's an admission against interest in the statements in the criminal case, and this is the case law, and I'm looking at Anderson versus the state, 360 Georgia App 291. If it's in a criminal case, it exposes that the declarant to criminal liability showing must be of the corroborating circumstances that clearly indicate trustworthiness of the statement. So my original ruling would stand on that issue, that you'd have to be able to show where it came from, even though generally a repost can't be changed, but I don't know that. So I would have to hear something about that. So I'm not going to take it as a statement against interest. I will, however, hear any argument as to whether or not it still falls within an admission by a party opponent.
Does the court have a preference for when each side speaks?
Love is ready.
Okay, go ahead.
So, Your Honor, under 24-801D2A, admission by a party opponent, I believe the question raised was whether it was an admission. 24-801 defines statement as an oral or written assertion. In this particular case, there was an oral assertion that if you lie to your folks and get in court and tell the truth, you need to be killed. That's from me and YSL. But 24-801 also defines a statement as nonverbal conduct of a person. The nonverbal conduct was capturing himself saying that, memorializing the assertion, the oral assertion that he made. So the exhibit itself qualifies as a statement because it contains both oral assertions and nonverbal conduct. And so therefore, under 24-801D2A, it is a statement of a party opponent, which is admissible without the presentation of any predicate or foundation. Additionally, Your Honor, 24-801D2E would make anything said by the people behind him who are co-signing as to what he is saying co-conspirator statements. They are literally.
We don't know who they
Right.
are, so.
Right. And so what we hear happening by the primary and only relevant speaker, and that being the defendant Williams, is as he is saying, y'all need to get killed, bro. That's from me and YSL. There's no rejection or rebuking or anything like that of the snitching bitching statements. So essentially, he's adopting those as his own as well.
He being Mr. Williams, so purportedly, right?
Yes.
Okay.
And so we primarily stand on the admissions by a party opponent. And as to the commentary that is also heard, we would argue that Mr. Williams has adopted those and that any argument to the contrary goes to the weight and not the admissibility of the statements. And the jury is a proper entity to weigh that statement.
All right, ma'am.
So she previously acted like Jeffery Williams is the only one you can hear on this video recording. Now it's, well, yeah, you hear other people, but Jeffery Williams is adopting the things that they're saying.
Thank you.
Mr. Steele?
Your Honor, I found a case, it's United States versus Rodriguez, which is ROD, RIGUEZ.
Hold on 1 second.
And is this a 2011 case?
It
Yes,
looks like it's 2011. Is that correct, Mr. Steele?
correct, May 25, 2011.
That would be before the new evidence code.
Right,
Take
in
effect.
Georgia, but it's 11th Circuit, so we adopted their evidence code. That's what we did. So this would be the law that from the 11th Circuit.
All right, so what section are you asking or inviting my attention to?
C and then 1. It's maybe halfway down in the opinion.
C and then 1?
Yeah,
Okay.
so it starts with C and it's titled, "The District Court Did Not."
And this is a late thought. I should have paused like a couple seconds ago, but notice how quick Love is to recognize when something's before or after the evidence code when she doesn't want to hear it.
Abuse its discretion in admitting evidence. There's a paragraph explaining it and then goes into 1.
Hold on 1 second, sir.
Okay, and then, I mean, it's a short passage, we can read the whole thing, but I liked it because it targeted both what you said, Joyce, and I heard what you said after I found it, but 801 D2A as well as 801 D2E, it was in the same case. And in the third paragraph of Division 1, it states that the district court also acted within its discretion when it concluded that circumstantial evidence coupled with Rodriguez's self-identification authenticated the telephone conversation sufficiently to satisfy Federal Rule 901, which is corresponding to Georgia 24-9-901, which provides that the requirement of authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. And that's what the court just found, and what I've been saying, they don't have, to my knowledge, right now, any evidence that this repost is what it was originally. They don't have the date on the original statement. So that is my position again.
And Your Honor, we don't, in 24-801 D2A, which is our statute, it has no requirement of date and time as Mr. Steele is asserting.
Authenticity.
And specific.
That's different. Authenticity is different.
Exactly.
Authenticity is different. It's 901.
But, okay, it's the authenticity of it's a repost.
Okay.
I'm not saying
But, okay, but Mr. Steele, that would only be, for example, if I couldn't, or nobody could make out that that's purportedly your client, that would be indicia that it's not reliable, okay? But there's nothing in there that's shown that the postings have been distorted. It's not readable, it's grainy, whatever. So there's sufficient indicia that that's your client. I mean, I would argue that from looking at what the state has tendered or proposes to tender as in this exhibit, 111, I should say 112, Bravo.
I'm not claiming that someone recently did not say that's what I'm not claiming.
But that goes to 901, and it goes to whether or not it could reasonably be that it's your client and there's other and it's reliable. So.
Is there something beforehand? Is there something after? The words change. The other speakers are identified.
But there's nothing in there that would indicate to the court that has occurred. If there was, I would certainly take your argument, and that would be more applicable. But I understand, sir. I'm gonna basically overrule that particular. I'm not gonna overrule it, but I'm gonna go ahead and I'm considering it for the proposition it is.
Your Honor, in regards to the statements of other people on that video, those are not admissions by Mr. Williams. So are those being redacted? I recall, despite what was said at the bench, that the tape actually, I think at one point someone says this is from YSL, B word or something like that. And those are not words of Mr. Williams.
Okay, but Mr. Williams, if you believe the state's argument and the jury can decide for themselves, he's co-opting that particular person's statement as to the circumstances.
Well, and I have an argument about that. Essentially, what we're talking about under the law is the case law refers to as an adoptive admission. And two things.
Well, no, it's different because you're still dealing with statements of a party opponent, okay?
Right, but if it's not the person, if it's not the party itself making the statement, then the only way it's admissible is if it's adopted by the party. That's what an adopted admission is. And according to the 11th Circuit and the case law, it's very limited case law in Georgia, but two criteria must be met. First, the situation must be such that the innocent would normally be induced to respond to the words of the other person. And second, there must be sufficient foundational facts from which it can be inferred that the defendant heard, understood, and acquiesced to the said statement. And this is my argument. It's going to be by analogy. I'm on the phone with Mr. Steele. We're talking about the day we were in court, and then Mr. Steele says, and Max, remember that armed robbery that we did in 2020? And then he hangs up the phone. Well, I didn't have much of
That's a little different. Because that's called a tacit admission. That's a statement that somebody, listen, that's a statement that somebody makes that you expect them to say. It's just like, like somebody who says, did you hit Frank? I didn't.
Well, right.
You'd expect somebody to deny that immediately.
Correct. But from my recollection of watching the post, that last part was said at the very end of the post. And there was really no opportunity to respond, to acquiesce, to do anything. And then the post ended. So my argument is, I agree with Mr. Steele that it should not be admitted at all, and that's my stance. But if it is going to be admitted, the words of a third party, I don't believe that Mr. Williams' lack of chastising the person, whoever said it, in the 1 second that the clip continued before it was turned off, constitutes an adoptive admission. And so
All
that's
right.
my stance.
Thank you, sir. All right, State, you wish to be heard on that issue.
Yes, Your Honor. What is happening, as the court heard, is that the person who is echoing Mr. Williams' comments about people who come into court and tell the truth need to get killed, that's from him and YSL. they're actually echoing Mr. Williams' statement as opposed to Mr. Williams' statement simply adopting his. The other thing that I would point out is that this is a much different situation than, say, someone taking a selfie and getting photobombed unknowingly by Mr. Brown standing behind me until I look at the picture. Mr. Williams has a camera up to his face. He is video recording himself, and it's audible to a listener that words are being spoken. He did not have to keep that recording. So
I don't know, but if you're busy looking at a screen, you might not be taking in everything that's happening around you. So, but Max Short didn't really get into that nitty gritty. He just said, was it induced? Was it reasonable to expect that he heard what was being said and would have known he was supposed to respond? Or, say, no, I disagree with that.
his nonverbal conduct was the recording of himself and the capturing of that echoing or that co-signing of the person who is signing on to what he just said. It's not a simple matter of Mr. Williams adopting or not adopting the person behind him. It's the person behind him echoing and adopting his admission. And by recording himself and that person on that video recording, Mr. Williams is essentially signing on to the sign-on, if you will. He is agreeing with what that person is saying. They are synonymous. Snitching bitches is the last thing I think that someone said. And that is essentially the same as you come into court and tell the truth, you need to get killed. That's from me and YSL. And so, as I stated earlier, Your Honor, under 24-801 D2A, given the definition of statement as both an oral assertion and as a nonverbal conduct, the oral assertion qualifies as a statement that Mr. Williams is making, that a person who comes in and testifies should get killed from him and YSL, and the nonverbal conduct is recording himself and the person co-signing with him on a videotaped medium.
Your Honor, the state in their argument just made a whole bunch of assumptions that there's no evidence to support. They just stated that Mr. Williams was taping himself. I don't know how we can make that determination. They said that Mr. Williams decided to post it himself. I don't know how we can make that determination. And that's the whole point. We don't know these things. There's a lack of foundation.
In terms of what, sir?
Well, I mean, they just said that Mr. Williams taped himself. I'm not agreeing to that. They're saying Mr. Williams chose to post it on the internet. I'm not agreeing to that. So these are the foundational requirements that they're just kind of stating it as so, but I don't believe that that's been proven. So, and that's relevant to the issue of the adoptive admission part, or as you called it. I think we're talking about the same thing. You called it tacit admission. I call it adoptive admission. I think essentially we're talking about the same thing.
Sir, I'm sorry.
I will say this, I don't personally have any knowledge that this is on Mr. Williams' social media. I cannot find it. If I'm wrong, I know the state didn't give it to me in discovery like that, and I don't find it. And I'm not going to repeat myself, but we started this whole thing with there's no other person in the background except yay, yay. Now other people are saying things in the background, but it shifted so much. And I just still think that the bottom line is somebody, the proponent of the evidence is the state of Georgia. Somebody has to come in and say, yeah, this wasn't altered. This is when it was made, and this is accurate. And we don't have that. What if this was made, Your Honor, in 2014? Just for instance.
But the challenge is that under current Georgia law, as it pertains to admissions by a party opponent, it's admissible without presentation of predicate or foundation. Unlike if you have a statement against interest, or unlike if you've got conspiratorial statements, there are a couple other things that need to be brought up. But this particular statement is being offered for the admission by a party opponent, and that's what the law provides under 24-8-801 D2A.
Not really, because if you recall, posted the state said it's being offered as a statement also of a party co-conspirator, excuse me.
Okay, that's different. That would be under E.
Right.
And E requires different, but however, looking at E as well, conspiracy need not be charged in order for OCGA 24-8-801 D2E to apply. For evidence to be admissible under this rule, the government must prove the existence of a conspiracy by preponderance of the evidence. In considering whether a conspiracy was established for purposes of this rule, courts do not require the conspiracy to be proven prior to the admission of the evidence in question, but only that the conspiracy was proven at trial. So, but their primary purpose is under 801 D2A.
And please correct me, but I believe the foundation is needed because remember how the state is using it is they're saying they charge it like this. They put it in the overt act. I think you said 26. I can't remember. I think you said that. They put it as a repost or posting by Mr. Garlington. It's not Mr. Garlington's statement. They're saying that it's Mr. Garlington's statement to warn people because they're in a conspiracy, so it's a co-conspirator statement. So I still believe that the statement originally by Mr. Williams has to be authenticated, as we've been discussing.
The law does, I don't think it does. I mean, there's nothing in here that says that that statement has to be authenticated. It just says co-conspirator statements may be admitted when the prosecution shows by a preponderance of the evidence that a conspiracy existed. 2, that a conspiracy included the declarant and the defendant against whom the statement is offered. And 3, the statement was made during the course and in furtherance of the conspiracy. Where statements, however, admit participation in crime but do not evince an intent to commit further criminal activity, Rule 801 D2E does not authorize their introduction. I would submit from the court's perspective that the statements could be considered by the jury for the other purposes of what your client said about people coming into court, making purported statements. So I believe that it would satisfy still the dictates of 801 D2E. But remember, the state's offering it under 801 for count 26, but also for the overt act under count 1.
So,
And I'll give that, we can hash out that when I charge the jury. Well, because it's going to depend upon some other things if we get to that point, and some other things that may develop in this case. So I'm not saying to you that we may not have a distinction between that, but at this point, I believe it'd be admissible.
okay, and listen, I respect your ruling, but that's why I found the Rodriguez case, because it discusses both 801 D2A and 801 D2E in the same C1 section, and they discuss specifically the authenticity under 901. That's why I thought it was a good case.
Okay, I understand. State, have any further comment about that?
Your Honor, we believe 801 D2A is clear as it relates to foundational factors. And that along with the policy and rationale behind it makes the evidence that the state seeks to admit allowable. And we ask.
Okay. All right. I'm going to allow the state, allow the state's 112 Bravo, the statement made on January 26th of 2015 over objection. And I'll make it a continuing objection. It's all concerned. Okay. All right. Yes, sir.
Before the jury comes back in, can I talk for this? I'd like to say something.
Else?
Your ruling's done. You've already ruled. That's fine. We accept that. But I want to address something to the privilege bench that I want the court to address.
Sure.
Here we go with Keith Adams on fire.
And I just need about 3 or 4 minutes. I've got to say this because I've been sitting there after our conversations. Let me just preface it by saying, in any of our objections, whatever, you make a ruling. Sometimes we win, sometimes we lose, we move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier. There was an objection to the video, you made a ruling, we moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified, all right? And Madam Prosecutor said to you, and was not accurate. And I'm going to be charitable and say that she was disingenuous. What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mrs. Steele is not accurate. What Mrs. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this. After you decided to reconsider, you want to hear the video yourself, you had a chance to hear. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio, that were in contradiction of what Madam Prosecutor said. On God. Snitching bitches. I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. Fuck nigga. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you to, we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah, we've had that conversation about it. And when we step up to you and we make a representation, it ought to be candid and it ought to be truthful. And what she said, and look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right. You heard Mr. Steele. Mr. Steele said, Your Honor, I am willing to surrender my bar card and have her surrender her bar card if what she is saying is true. He wasn't wrong. She wasn't wrong. She was not candid with the court. And at some point, you've got to say to the parties, if I've done that, I would expect you to say, Mr. Adams, don't do that again. Don't step up to me and lie to try and get me to rule or overrule something I've already ruled on. Don't do it again. You ought to say that to them. We're not playing games in this courtroom. These are these people's lives at stake. And like I said, sometimes you win a motion, sometimes you lose. But you don't get the court to address something or readdress something like that. That's all. Say something to them is all I'm requesting.
All right, sir.
May I speak?
You may.
Your Honor, I would not have asked the court to listen to the 17-second video.
But what you did tell me, Ms. Love, wasn't the entirety of what was purportedly on states 112 Bravo. It did have other statements on it. It's different if you'd have told me, Judge, there are statements on there. Probably need to listen to them for yourself. Not just yeah.
Your Honor, my recollection, and I'm going to speak candidly because it's been.
I would hope there'd be nothing less than candor.
And Your Honor, that's what I've been pushing for all along. There have been times, as the court is aware, that we have been at the bench and misrepresentations, bald misrepresentations have been made, and the court has seen my reaction to them. I am the one that's constantly saying I have a duty of candor to the court.
All of you do. All of you do.
We do. And when Mr. Adams just read those series of things that he read, those half of what he said, I didn't catch. The part that I did catch and remember is the part I kept repeating just now, snitching bitches. And I didn't even recall that part was there. But what I did know.
So if you didn't recall that they were there and you listened to this over and over, 17 seconds, how is your argument that Jeffery Williams clearly heard it and adopted what was being said? Either you're being disingenuous or you're backing up the argument that the defense made on why that, at least that part, should be kept out.
Was that the relevant portion and the relevant speaker was Mr. Williams. And Your Honor, I'd ask, we can do this in chambers or wherever, but Your Honor, I believe that certain requests and comments to the court have risen to a level of being not true motions or requests based on legal analyses, but more leveled specifically on a personal level, which I've attempted to stay away from. Whatever one.
But the judge just agreed that Keith Adams' characterization of the representations you made, the misrepresentations you made, did actually happen at the bench.
Reason for doing what they do, if it's to better advocate for their client, that is fine. They're entitled.
Well, you're not entitled to do everything in whatever position you're from, be it the state or be it the defendants, because you have a overall right of candor, responsibility of candor to the court.
I agree, Your Honor.
There are certain things you just cannot do anyways. Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your respective sides. And as I said a couple of days ago, what the public sees is there's friction between the state, the defense, and the court. That is natural, and it is good for the system because it shows that we are not in collusion with one another. Justice is what it will be, and whatever this jury will decide. But what I am going to just advise everyone to kind of relook is what you tell each other, what you tell me, because there have been times where I have not received, I would consider what is accurate information. Let me just put it that way. Okay. And I know, and I'm not trying to attribute, dishonesty to any party, but I have to rely, all courts have to rely upon counsel for their representation. So If you can't remember what it is, just say, tell me that. It's just like your duty to, when upon asked if there's any adverse position to this particular statute of law, you're required to tell me. I mean, I mean, I understand there's zealous advocacy, but I would also just remind everybody within the sound of my voice, professionalism really does matter to you all, and it matters to the court, and it matters to those that are watching this particular trial. Yes, there have been some times that these proceedings are acrimonious, or intense, and the court has had to chastise both sides for things that have occurred. I don't have any personal issue. Remember what I told you. I tell the jury this when I charge them. The court has no interest in this case. My sole responsibility is to see that it is tried fairly as to both sides. So, and I maintain that in terms of I respect everybody in here as advocates, but I do need to have you just relook what you're saying to each other and to the court, because it really does make a difference in terms of our presentation before this jury, and then ultimately the jury is going to make a decision. Please remember, at the end of the day, this won't be the last case you try one another, and won't be the last issue that you try. So, but the court understands that you have a job to do. But understand that I have a job to do as well. I'm the referee. I have to determine what comes in and comes out in terms of my functions. So understand, at the end of the day, we have that similar goal, but I understand you all have dissimilar objectives in terms of what the agencies are in terms of your roles and responsibilities. But don't ever forget your duty of candor to the court, your duty of professionalism as advocates, and the duty of civility. It still applies in criminal cases as well. These defendants are presumed to be innocent, and they are innocent, and that's what this jury will ultimately decide. But we'll have to get there, and they'll make a decision. Okay.
And Your Honor, I'm certain the court means until proven otherwise, they are presumed innocent until
they're innocent right now as we sit here. So, and until I charge the jury accordingly and otherwise, and the evidence is presented to them, evidence first and then charge them. But as to how this case goes.
Thank you, Your Honor. And thank you for addressing also the concern that I have, because that is my main concern, the level of civility and the level of personal commentary level that is, in my estimation, not necessary. And I appreciate the
But that's
court
everyone, everyone's can be accused of that at various times in this particular trial. I mean, I think that every issue that you have secrets, anything that's been raised at this point in time, anyone who's sitting in this courtroom is probably violated at some point in time or another. However, let's just try and do better in terms of that. But just like I told you with evidence and the other things that need to be brought forth, let's try and do better with that, because certainly, as I mentioned earlier, I don't want to have the jury sitting here for long periods of time. When we take up other business, so we need to plan accordingly. But I think you all could probably, do a better job at least forecasting what is going to be tendered or submitted, so that we can minimize delay. So, I mean, to the extent you all started to do that, it seems to be working a little bit better, but we'll see how it goes. All right. All right. So I've ruled upon 112 Bravo. What I'd like to do is how much do you have left of your witness here?
I wanted to play that video, Your Honor.
So how much?
It was, I believe, 17.
Okay, so how much more do you, just estimate, okay? And I'm gonna double whatever you tell me. So how long do you think you'll have more of Sergeant Gaither?
After that, I will pass it.
All right.
But then they get Gaither back in, the jury's back in, and they're going to do this 17-second clip in front of the jury.
All right, Ms. Love, you may proceed, madam.
Thank you, Your Honor. Permission to publish State's Exhibit 112 Bravo.
Any further objection that has otherwise been not noted or for purpose of the record? All right, I'm going to admit State's 112 Bravo over objection with the caveats that the court has already ruled upon, and it may be published as you see fit.
Thank you, Your Honor.
So, nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters didn't get ready in the courtroom and tell the God honest truth.
Fuck, nigga.
Don't get it. Y'all niggas get fucking killed, bro.
You snitching bitches.
From me and YSL.
Also notice all of the comments on the side just visible. All the comments on the side are just visible too.
Sergeant Gaither, is that the video that you were able to capture from the account that you spoke of earlier?
Yes.
Thank you. Your Honor, at this time, I'll pass it.
All right. Ladies and gentlemen, given the fact that it is Wednesday at 5:05 and we've had
So we've had all of that. And I skipped all of the recesses where they may have been doing more research. I skipped through some dead silence in the court. We also sped through some of the sidebars, even though we looked at some of the body language and to see who was arguing when. But we really sped that up. But that was a lot of time. That was like 3.5 hours or so of time on this day, day 67, where this issue took up the court's time. And the jury was just hanging around waiting to play this 17-second clip. Now, I'm not going to repeat it. What did you hear in that clip? And you're hearing that clip now after maybe you saw this day live and you heard them argue about it. But what did you gain from that 17-second clip? If you were a juror, what do you think you would have noticed or heard? But with that being said, the point of this video was, even though Glanville, sustained the objections at first, Love found a way, and it was a disingenuous way to keep the argument going and going and going and going until finally the ruling was in her favor. And even when she was reminded of her duty of candor to the court, she insists, "Oh, I take that very seriously, of course." Well,
All right,
does she?
well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms.
Your Honor,
Love.
respectfully, I take it very seriously.
Okay,
So there you go, you guys. What do you think about this whole debacle, this debate over this 17-second video? 112, bravo, bravo. I said Brady, Brady earlier. Whatever. I remember seeing it live and just thought, this is exactly what she does. Just badgers and badgers and badgers until she can get the ruling that she wants, get the reconsideration that she wants, and doesn't care if she's wasting the jury's time. And we're about to enter day 114 tomorrow on Monday. I don't think much has really changed with how Love pursues her objectives. But with that, I'll turn it over to you guys. You guys let me know what you think, and see you tomorrow. Remember, no jury, but we'll have a bunch of arguments, and we've got a bunch of homework. We'll see if the state is turned over. We should also be getting a new filing from Diamante Kendrick, Doug Weinstein. That was filed, I think, Saturday, but we'll probably see it come through tomorrow morning. So probably some exciting stuff going on in the courtroom tomorrow outside the presence of the jury. See you then. You guys all take care. Bye-bye.